Good morning, everyone. My name is Jalen Carter. Thank you again for joining us for our Lunch and Learn series. We're really excited today to chat with you all about patents for disruptive technologies and strategies for the AI era. Today, we have some amazing speakers for you all. We have James McParland and Jolene Fernandez. They are going to give you a bit more information about themselves. And with that, I'll pass the floor over to them. James, Jolene, it's all yours.
Hi, everyone. My name is Jolene Fernandez. I am a partner in the Boston office of Foley and Lardner. I'm with the Chem Bio and Farmer Practice Group, and I've been at Foley ever since the summer, all the way up to partnership. My current practice focuses on IP prosecution and counseling, everything that ranges from the creation of IP assets to commercialization and monetization to enforcement of IP against the adverse to third parties. And my technology experience runs the gamut from traditional biologics, whether it's antibodies, stem cells, siRNA, CRISPR-Cas gene editing, all the way to the application of AI in med devices and theranostic applications, particularly in the field of precision oncology. And with that, I'll hand it over to my colleague James or Jim.
Hi. Everyone knows me as Jim, so that's why if you call me James, I'm probably gonna look blankly at you. So Jim McParland, partner. I happen to be in the Madison office. I'm not originally from Wisconsin, for better or worse, as much as you might think. I'm gonna also shout out to my colleagues' credentials. Jolene has her PhD in biology from Caltech. And so, like me, I have my PhD in organic chemistry, medicinal chemistry from the University of Kansas. We both are scientists who happen to get our law degree as well. I am a partner about over 13 years now with Foley. Originally started off doing some tech transfer with Matt Koenig, who's with you. So if you ever want to ask Matt Koenig about me, you'll see him sweat and go into a negative place and have to relive some horrible stories, but he'll tell you them, I'm sure. And so similar to Jolene, we run the whole gamut and we work with a variety of people from individual inventors, people at universities, all the way up to big corporations. Um, I myself also have been heavily involved in contested proceedings as well as just getting patents going at the beginning. And a lot of this is like the non-patentable stuff because it's not all patents all day, every day. That's just not how one lives. It's a broader consideration. Um, and so, with that, we'd like to want to dive into AI. And so I can give you an overview of what we're talking about, but here's some things that we're not going to talk about. Um, when you have AI, you're training it through certain data sets, through certain learning models. What you give it as data can have things you might want to consider. Like, is this patient data? Because then HIPAA might govern what I feed in and what might be governed by it. Is this okay or not okay? Am I having it generate something? If what I'm having it generate can be traced back to an original data set that's, let's say, protected by copyright or certain other uh, protections by, let's say, some big corporate people who really like their stuff to be themselves, that could be an issue as well. And why do I say that? I'm not trying to fearmonger. None of this is meant to be fearmongering at all. These are just considerations. Some of the stuff when it comes to AI and data sets, it's great to talk to Tulane Innovation. Just get their beat on it. Just make sure that we're doing it the right way. But what we're talking more about today is like patents. So those are other considerations, which in fact go into broader topics. And of course, this is a hot area. It's just gotten hotter. And now people are starting to wrestle with it in various capacities, much like with things generated from patient data, even when it comes to drugs or therapeutic methods. Hot in terms of where this data come from. What's the output? Can I patent that? Was I wrong in using patient data to begin with? So you just want to start off with like current trends in AI patents, what you need to think about if you're developing a patent portfolio, but beyond that too, like what is the broader consideration regarding your technology, your intellectual property, and a patent? Because all those things come by. Because mainly you're doing this because you want to do the research. You want to help. You want to innovate. You don't want to be bound by patent. You're not working to make patents. And so that's why these considerations are broader than just patents or a patent portfolio, but they all tie in. We'll then go to patent eligibility. That's law consideration as to whether they consider something patentable or not. Some of the statements in both patent eligibility and what is considered an inventor sound very strong, like significant contribution versus insignificant contribution versus obvious and routine. These all sound like very damning words to people who actually work in science. They're legal considerations, they're legal magic words, can you say? We just happen to put them into that framework. But understand that there's kind of a divide between legal speak and scientific innovation. We try to marry that, but just know there is that divide. So it'll be things that are said that seem somewhat pejorative. And unfortunately, that's just how the law states them, as opposed to how they might be regarded by real scientists. And so, as you likely already know, AI going everywhere, fraud, in fact, artistic works. You see it being used to generate designs that might end up on what otherwise look like clothing and wardrobe manufacturers, where the AI will like generate it up in almost in real time, as well as drug discovery, energy, other development, medical diagnosis, surgical applications.
Hi,
So
Jim.
yes, go ahead.
Jim.
Yeah, Jillian.
Yeah, so sorry to interrupt. I'm
Always,
still
please interrupt.
seeing, I'm still seeing the collapsed view of your slideshow.
Oh, weird. Okay. Let's see if we can change that. Let's see if it's odd that it's giving the wrong screen, but let's just change.
It might just be my computer, and if it's just my
Nope, it's
computer,
likely
It's
just
like yeah, no, now that I'm seeing it, it's still stuck at the first one, the first one.
let me change that. How's that?
There we go.
Hopefully better. All right.
I'll say.
So AI knows that we're talking about it, hence what just happened right now. If you've ever seen movies 2001: A Space Odyssey, Terminator, Skynet, this is what's happening right now. They can mess with this, and that's kind of the concern. But here are the concerns we're more going about, IP, your technology, whether or not they can take over your computer during a presentation, we'll leave till later. I'll say all hail machines, just in case they're rising right now. But in terms of trends overall, internationally, it's been going since 2000. The ones that are in the lead are unsurprisingly China, US, Europe, Japan. The more interesting part is this in 2022, because that's when we have like more decent, robust statistics. AI patents for China versus AI patents for US are a huge disparity. 40,000 AI granted in China versus 9,000 in the US. Part of that's due to subject matter eligibility law, but part of that's due to other considerations. US large corporate entities seem to be the ones driving it, whereas AI in China seems to be more distributed across the different organizations, understanding that these different organizations somehow have some government tie-in. That's just how that jurisdiction works.
Right. So
And I'll pass it on to my colleague.
thank you, Jim. Do you mind manning the clicker while we go through?
Of course.
Excellent. So that being said, in terms of the current trends in the AI patenting world, what are some of the considerations when it comes to actually developing a versatile, robust AI patent portfolio, and as Jim alluded to earlier, in some instances, the patents may not be the right instrument of protection. It can vary. In some cases, it would be treated trade secret. So, starting right up top, you consider for your particular AI based platform, what is the most appropriate vehicle? Should the protection be through trade secret, or should it be through patent protection? This depends on a number of further factors, such as how will your AI-based technology become commercialized? Is the commercialization supposed to be through a software as a service model or a SaaS model, or is it meant to be just hidden behind walls and be performed internally, which pretty much shields the consumer or the general public as to knowing what exactly is being implemented, right? The more it's like the more protection you have in terms of being less public facing, the more likely you can go the trade secret route. But if you're offering it as a SaaS model or software as a service, patent protection may be your better bet. The twin consideration that stems from the commercialization strategy also depends on how easy is it to reverse engineer your particular AI based platform. It's like the easier it is to reverse engineer, the more thoroughly you look at the patent protection model as opposed to not. This also stems another consideration is overall publication plans. A lot, I mean, so a lot of AI, but while it's being controlled and developed by larger corporations, academic institutions are also part of the mix, right? And they're academia-based research plans also factor into play. It's a publish or perish world. So if you're pretty much developing a system and you're in an academic field that requires frequent publishing. Once again, the scales tip more towards the patent protection angle. Another consideration is what exactly is the basis of the novelty or the inventive step for your particular for your particular AI-based technology? Do you have a newly developed AI model? Are you making changes or improvements to the relative architecture of the structure of a known model? Are you adapting an AI-specific component to perform a particular practical application that hasn't been done before? Jim, do you mind transitioning to the next? The second major bucket here would be considering whether or not you're resorting to a defensive IP strategy versus offensive IP strategy. The defensive IP strategy is what we colloquially refer to as the salt the art technique, where your major consideration is to block third parties from obtaining patents to the technology, as opposed to like getting coverage for yourself. In this case, you'd pretty much file defensive patents to just block your third party competitors from securing any IP rights to competing AI-based platforms. This doesn't mean that they won't enter the market. It just means they don't get exclusivity. An offensive patent strategy is one where you're pretty much crafting the patent filings to cover your keys, your core commercial product or service. Do you intend to use your patents as licensing instruments to generate revenue, or to use as bargaining chips for cross licensing with another entity? And the last one I wanted to touch on, which has become more and more of a key trump card in the within the last decade, is using certain patents as strategic assets in contentious proceedings against your third party competitors. It's like, once again, it's like the patent filing strategy is also governed by the likelihood of success in prosecution. Just because you file a patent doesn't mean you necessarily get a granted patent application. Sorry, just because you file a patent application doesn't mean you necessarily get a granted patent, right? That's going to depend on the laws of the various commercial markets you're interested in. As Jim pointed out earlier, it's like AI within the U.S. It's not the filings and the grants are not as high as China. Part of it is due to our patent subject eligibility laws, as well as other market considerations. And of course, along with any strategy, the key question here is to ask, how does your portfolio align with your current or your future commercial objectives, or if there are other strategic business rationale you may have internally? With
And
that,
so,
go ahead.
as we chain off, we've been talking about the defensive versus offensive. Generally, a salt the earth type thing is something that like a big corporation will do because they have a lot of resources. They're less worried about creating things that they can't get around in the future, like ruining their own research plans. But the thing that we keep talking about is the subject matter eligibility, like U.S. versus China. Like, what do we mean by that? Well, that's just a framework of like the law in terms of what the Supreme Court and US law thinks can be patented. And this has been in flux. This might continue to be in flux. Um, and so it seems really simple. The way that it was even stated in the patent law was anything under the sun, quote unquote. But then there's a aha moment. Well, they can't be absolutely everything, right? Um, and this is where we get into the things that aren't supposed to be patent eligible. And so what that's supposed to be is if it's somehow trying to patent a law of nature, a natural phenomenon, or an abstract idea. Why do I say it that way? It seems like that'd be simple. Well, certain natural products, they've said those are natural phenomenon. You don't get to patent that. Could be Congress changes that law here in a little bit. Abstract ideas, one will point on here in a little bit. That seems really interesting in how they try to apply it. The concern by the Supreme Court was, of course, you're going to prevent people from somehow doing things that have already been out there, or doing things that are so diffuse that everyone does it. I make everyone, my enemy. I can go after anyone. But the way you can get around it, and the way that an attorney should be able to help you around it, is by somehow taking what would otherwise be considered an abstract law of nature, something, and bring it to a practical application, so that the what you are claiming, claim being a patentee's term as to how you describe the technology in the patent application, in whole, is more than just this sort of law of nature, more than just a natural phenomenon, more than just an abstract idea. They've tried to make flow charts to help as to whether something is or is not patent eligible. As clunky as this might look, it's even clunkier in application. So we have some little high-level examples that we'll be going over later. But in terms of like getting into some of the more of those details, just to help out, just so you can see where someone might go and to help with the strategy regarding AI specifically, I'll turn it over to Jolene.
Sure.
But before I do that, we're talking about AI right now. Know that the output of AI, should it be like a product directed by AI, that's under different patentability considerations. I'll touch on that towards the end of the talk.
As Jim alluded to earlier, yes, you've got that simplified flow chart in terms of how eligibility is determined, but practically applying the framework is not as easy as it looks. It's like both the courts and the USPTO have now provided extensive guidance as to what they would like to see. And in some cases there have been conflicting, but or the contradictions between the patent office and the courts, and that's still being sussed out. So the best that can be done is by observing the guidelines that the PTO puts out, because that's what the examiners are bound to, and but also including alternate backup positions just in case those go sideways by another rogue court ruling. So one of the things they repeat again and again, you should do more than just simply recite the judicial exception, or like the natural phenomenon, or the abstract idea, or law of nature. But it means it goes beyond saying just apply this law or equivalent. So for example, merely merely instructing a computer to implement a particular abstract idea is not enough. For example, if you wanted to, if you took the sum, if you took the sum of various phenotype scores, or dozens of patients populations, is that something that can be done mentally, just within your head? And are you just asking the computer to do it? That does not rise to the level of patent eligibility, because you're just taking an abstract idea, or something that can be performed mentally, and asking the computer to do it. Can the computer do it faster? Yeah, but that, once again, that doesn't rise to the level of being significantly more. It's like merely having a computer replace what the human mind can do is not enough. So some of the strategies that are typically deployed when crafting AI-based platform claims is to look and see whether or not the claim, does the claim do more than just recite the idea of a solution or an outcome? So, for example, if the claim fails to actually specify how the problem is being solved or how the solution is being arrived at, it's likely not going to pass muster in terms of being patent eligible. It's like, are the computers or other machinery merely used as a tool to perform an existing process that can be performed mentally or by some other routine rote means? Once again, not enough. There has to be something extra, so there has to be a specialized function or role for the computer in order to come in to make it rise the whole significantly more. And the last factor that's typically considered is the actual language of the claim, like how particular or how general is the language when it comes to the application of the judicial exception or the AKA the abstract idea or the natural law. And we've got a couple of examples to kind of illustrate this point so that you can have a gauge as to how that works. So as of now, so typical examples of AI-based features that have been found patent eligible by the U.S. Patent Office can include, new training frameworks, novel arrangements of certain nodes and layers of logic systems within the model, including certain activation functions, or removing functions that were thought to be vital for a particular model to actually spit out a solution for an answer. Certain data cleansing techniques or data filtering techniques to reduce noise. Methods for defining certain, new feature vectors, using methods of using hardware to execute the AI model more efficiently. As well as the last one, which includes modifications to an AI model that improves prediction accuracy, which is pretty much like a key one that's being deployed within the theranostic space, particularly when it comes to precision medicine and precision oncology. Let's jump over to the next one.
So I can just start off just in terms of examples. So, this is one related to an artificial neural network. Okay, a circuit for an artificial neural network, and it talks about a plurality of neurons in an array. Can't even say the word. And a microprocessor and at least one input. It's pretty broad, vague. And that plurality, got it that time, of synaptic circuits, each one includes a memory for storing a synaptic weight. So this seems like a broad term. I got memory in there. I got like neurons. I got a microprocessor. It was deemed that this was an assortment of hardware components being discussed. It doesn't say or recite an abstract idea. And while you might train the neural network using mathematics, it's not recited in the claim itself. And so this was found to be patent eligible as not directed to a judicial exception. And you say, okay, if I talk about a neural network and I talk about some hardware components like a microprocessor, you'd think, I got this. Well, next example.
Yeah. So now take that example where we talked about the apparatus and start moving into the methods land, where things get murky and pretty dark pretty quickly. So here we have a method of using an artificial neural network that comprises the steps of like receiving the data, taking the trainer data, making it into discrete sets to generate some input data. You train the neural network based on the input data and some algorithm to generate a trained neural network.
Which is a physical step. I got to train it. I have to physically do something.
Right. But then the selected training algorithm includes a backpropagation algorithm and a gradient descent algorithm. Those look like mathematical concepts and abstract ideas. So okay, you then have the step for detecting an anomaly in the data using the neural network, analyzing the anomalies to generate anomaly data, and then outputting the anomaly data. Once again, once again, there's no real. Each step from A through F is very generic in terms of like, create an input, it's like take the input, train the neural network, spit out, just spit out an output. Now, if we were to go through through the same analysis, steps A through C all are recited as being performed by a generic computer at a very high level of generality. The step D, which was the detecting step, it doesn't provide any details about how the trained neural network operates, so how the detection is made at all. And once again, as a reminder, this claim already recites algorithms which are abstract ideas. So that's already leaning towards like leaning against eligibility. Step E, which is the analytical step, can read on a mental step in terms of like how the anomalies are detected, or how the analysis is performed. There is no detail provided there. And step F, which just gives you a generic output. It doesn't pose any limits in terms of how the output is presented, or if there's specific components that are used to output the anomaly data. So this claim as is, by itself, is regarded as patent ineligible because it just is direct. It simply recites these high level abstract ideas and doesn't quite integrate it into an actual practical application. Now, if you wanted to, now it's like, now let's step back and look at a similar claim with with a couple of modifications that try to apply the guidelines that the courts and the patent office have put forward. So once again, step A, it's a method of using it's a method of using a neural network to detect malicious network packets. Step A means training the network by a computer based on input data and using certain algorithms. Okay, that recites an abstract idea because you have the mathematical algorithms right there. Step B, detecting one or more anomalies in the network traffic using the neural network. Still high level. Step C, determining at least one detected anomaly is associated with one or more malicious network packets. Once again, it doesn't tell you how it's gone about IDing those particular malicious network packets. It just says it does. High level. Detecting the source address associated with the malicious network packets in real time. But then you get to step E and F, which actually requires you, which doesn't just stop at the output. It actually involves dropping the one or more network packets in real time and blocking future traffic from the source address. So step E and F actually provide steps that arrive at a solution to solve the problem. What's the problem? Block malicious network packets. So running down the same analysis, steps A through D, they're performed by the generic computer by themselves. High level of generality. It's not going to get you anywhere. No real details about how the detection or the analysis is done. But in this case, steps E and F do specify remedial actions that are executed to prevent network intrusions. These are specific computer solutions that use the output to provide a security solution to the detected anomalies. So in this particular case, the combinations of steps D to F integrate these abstract ideas and these algorithms into a practical application, and it improves because the claim improves the functioning of a computer or a technical field. So these are so this is one example of how to implement these sort of strategies to move you into patent eligible territory. The other key lesson here that we want you to take away is just because the claim recites an abstract idea or an algorithm in one of the steps doesn't preclude it from being patentable, provided that you have at least one or more other steps that take that particular abstract idea and actually render it as a practical solution that's tangible, that's visible and readily apparent. And with that, I'll let Jim talk about the other example.
And the next couple kind of go to what Jolene pointed to earlier, that it could be, I'm going to put that in air quotes, it performed in the human mind. And then you get this weird blank stare about what might be practical or not. So this first example, it says receiving a Mitch speak signal, multiple C sources. Okay, lots of different sound sources coming in, converting them in a via time frequency domain using a short time Fourier transform. All right, I don't know a whole lot of people that walk around doing Fourier transforms in their head, especially multiple signal patterns. And then using a deep neural network to determine, certain vectors using a particular formula. This deemed ineligible because, again, I come back to that, just gathering data that multiple different sources say, well, we're gathering doesn't have a meaningful. I mean, I'm physically doing a step, but they say, well, what they're really concerned about is I talk about this Fourier transform. I talk about a mathematical step, and that's where the flag goes up with the courts. And apparently, because someone could possibly individually in their head do a bunch of Fourier transforms of complex signal patterns, they say that's not enough. Again, I don't know anyone walking around doing that. If you do, that's something, individual and special. It doesn't seem practical. And when it comes down to that last step, using a deep neural network, they say, well, it expressly states some sort of equation. And then the deep neural network itself seems pretty broad. You're just trying to mask it essentially. So they say that's not enough. And this is kind of where the back and forth goes when you're prosecuting, trying to get a patent. Change it a little bit. Now we're saying, hey, I received those mixed signal sources from speech. I use a time frequency representation. Again, this is still a Fourier transform in step B. I cluster, I apply binary mask, but the two new terms that are dropped in are converting these mask clusters into a time domain and then extracting the spectral features from a target source. Now, and here's the interesting part. They feel that this is eligible. Well, apparently a Fourier transform, people just go around driving their car while on the phone, and they just do these all the time. Apparently, converting these mass clusters into speech signals themselves aren't processes that can practically be performed to the human mind. Apparently, Fourier transforms are. Again, this doesn't necessarily mesh with what we go about, but it's kind of this negotiation process that we have to have because of the law.
And here's okay. So far we've been talking about high tech applications of AI. Here's an example of the use of AI within the theranostic space. So here we have a method that involves that's a method for sorry, it's a post-surgical fibrosis treatment method that involves collecting and genotyping samples from glaucoma patients to form a genotype set. Within the set, we identified the glaucoma patients as high risk for post-implantation inflammation based on the weighted scores that is generated from SNP data within the genotype set by a particular AI model. Here we're calling it the easy AI model that uses multiplication to weight corresponding alleles in the data set by their effect sizes. We add the sums, we arrive at a final score, and then we administer an appropriate treatment to the glaucoma patient who is at risk for PI after microstent implant surgery. The courts the courts have found, and the patent office agrees, though, that this is not patent eligible. Even though traditionally we think treatment, of course it's got to be eligible, but here's how here's how the rules break down. Step A, which once again is information gathering in terms of like the genotypes of the sample. Not it's like that's mere data gathering. It's an abstract idea. Step B recites an AI model, which just says it's a computer, but it's at a very high level that just says, oh, I have a model that just calculates this particular score. So step B by itself merely recites certain mathematical calculations and mental steps that can be performed in the human mind. Step C, which has an administering step, does not require any specific treatment for prophylaxis. All it says is administer a treatment. At most, this pretty much boils down to an instruction to apply the abstract idea without any real guidance. So So the courts here deemed that there is no improvement to the functioning of a computer or any technology. And since step C doesn't really offer any guidance in terms of the medical decision making, the combination it's like the combination of all three steps. It doesn't provide an inventive concept that's not well understood, not conventional, not routine. So you're out of luck. However, if once again, let's go back and rework the claim, and that's which is on the next slide, and we'll see. Steps A, in this particular post-surgical fibrosis therapeutic method, the genotyping and the scoring step are identical. The only thing that changes is you're administering compound X eye drops to the glaucoma patient who is at high risk. Now, in this particular instance, if you move on to the rationale, you are doing more than just simply saying apply it. So if you go on to the next slide, the key thing to look at is step C. Step C requires a specific treatment, which means that you are now integrating this abstract idea or these certain natural laws or phenomenon into a practical step. It also by specifying the compound, you take it out of patent ineligible subject matter land. And by specifying the compound, you don't need to go go further and consider whether or not compound X is a well understood routine or conventional activity. It can be a known drug, right? What's new here is like associating the drug to a particular SNP profile. But the fact that you are connecting a certain drug to that profile is enough to make it a practical exception. And the other consideration here, which the courts found more predominant, is because your final step, it doesn't it meaningfully limits the administration steps. That's what it doesn't mean you can get away with any therapy under the sun. You are limited to a specific therapy for a particular profile.
Now, some of the reasons why we give these examples is you see we have to, with the laws there's some navigating of how we say what the thing is and how we can try to get a claim to an invention that might not be necessarily what the inventors initially thought. We're trying to work with them to get that right language around it to get something that is considered patentable when it comes to this AI space. When it comes to patenting, it comes back to inventors, which I'll let Jolene take. Yeah.
Yeah. So, all right. So patent. So we went through the hurdles of patents and patent eligible subject matter. The other key hurdle now is is inventorship considerations for AI based technologies, especially when you're relying on the AI platform to help develop the invention. Under U.S. laws, inventors must be natural persons. We do not list the AI as an inventive contributor. So the use of the Patent Office has recently issued a set of guidelines to help provide some clarity as to what the standard of inventorship should be when you're dealing with AI assisted inventions. Now, AI assisted inventions per se, they're not categorically unpatentable for improper inventorship, right? But certain factors need to be checked off the box in order to make sure that you satisfy the inventor standard. Each listed inventor on an AI-based platform standard must contribute in some significant manner. The key word here is significant to the conception or reduction of practice of the invention. They should the contribution that they make to the invention should not be insignificant in quality when you measure it against the whole scope of the invention, and the inventor has to do more than just merely explain to the real inventors well-known concepts or the current state of the art.
And again, these sound like very damning pejorative words. What's significant? Merely, not significant, well known to the real inventors. Unfortunately, this is the way the law uses those words. We kind of have to like bring in those words, but this all sounds like very pejorative language. Yes.
Yep. So, okay. It's like, yeah, given the text of the law, how does that get interpreted? So if we move on to the next slide, here are the guiding principles that the Patent Office has put out as to in terms of certain scenarios where the human inventor the human contributions rises to a significant level of conception, and thus being true inventor versus not. So as I said, as I said before, a natural person's use of an AI system to create an AI assisted invention, it doesn't automatically negate your contribution as an inventor. The key point here, or the threshold here, is whether the natural person contributed significantly. What does that mean? So merely recognizing that there's a problem and having a general research plan to pursue it doesn't rise to the level of conception. So for example, if you have an idea saying like, oh, it's like I have a whole range of pathology slides that deals with this particular cancer, about like there's certain the certain tissue markers that I believe are predicted for recurrence, but there's it's like but there's inconsistency with the pathologists. I will let the AI it's like I will use the AI to train and develop it. But if all you do is just say, I have this broad idea without a real plan as to how to execute it, not enough. So recognizing the problem by itself or just having the initial research plan, not enough. Reducing the invention to practice alone is not a significant contribution that rises to the level of inventorship. There has to be some role of the human mind in conception. So merely recognizing and appreciating the output of an AI system as an invention doesn't make you an inventor. But if you are able to take the output that was generated by the AI system, make your own tweaks and modifications to it, to generate another output that's useful, that can rise. It's like that can rise to the level of proper inventorship. Moving on to the next point. A natural person who also develops an essential building block from what the invention, where the invention is derived, would be considered to have made a significant contribution to conception. So, and we see this a lot, but in AI platforms where certain folks came up with an actual training model and refined certain inputs or data filtering techniques to actually train the AI to accurately make certain predictions. So that's a very easy to appreciate example of an essential building block. So even though the person who helped create those essential building blocks isn't present or wasn't there isn't there when the final work product gets released, they still made a contribution, because but for their contribution, the AI system would not be functioning. And the last point is just maintaining just ownership or intellectual domination over an AI system by itself does not make you an inventor. So if all you're doing is just simply owning and overseeing an AI system that you're allowing our other folks to come in and use, without actually providing any significant mental contributions to the invention, does not make you an inventor. So the next slide actually is an actual fact pattern that applies some of these principles. So I'll let Jim take this one.
And this is a patent office fact pattern. So again, the patent office is trying to struggle with what law it sees out there. This isn't necessarily a court decision, but in short, there's a Dr. M. I'm going to hate these abbreviations, but this is the patent office example. Dr. M says, I want to make these new androgen receptor therapies, consults with a Dr. R who has this in silico drug target interaction prediction software to say, okay, can we get through and maybe get some leads out of this? Different Dr. L oversees the entire in silico platform. Dr. M says here are the drug compound inputs, which again, the patent office seems to be playing pretty broad as to what they mean by drug compound inputs, but they assume that they're just being handed off to the person actually, and just that Dr. R is just dropping them into the program. And then the program outputs 500 leads that are scored, and they give them the top 5 leads as they're scored by the program. It sorts them in a certain descending order.
Mhm.
So that Dr. M then comes into that list and says, these 5 seem to be more likely, goes to Dr. N and says, hey, can you like do some validation experiments, see if they actually work? And then after that, they modify that compound to bring a new, more selective compound, which is supposed to be represented by that structure in the bottom right. So M had the idea, gave the inputs, came out, identified things from the list. N did some wet work, but then actually did some modification with M, said we should change this, we should not change that to get a new compound. R merely inputted these compound inputs, and L oversaw the platform.
Hmm.
So in terms of a method of, providing something to a trained AI program and getting an output, where some of the steps there are then making some sort of selected drug compound and then modifying it. Under the PTO guidelines, they say, well, M and N, they are inventors because they identified the compounds, they identified the initial data set to put into the program. They then identified the top 5 potential candidates, and then they determined what modifications to make. And this is, again, that pejorative language when it comes to R and L. Dr. R merely, quote unquote, inputted these drug compound inputs
Mhm.
and then had them come out as a sort of output. And L, merely, quote unquote, oversees the entire computer platform. This doesn't seem like a realistic scenario. A lot of times when you're talking about a compound input, we're working hand in hand with this inventor as to what's relevant, what's not. The person interacting with the platform has ideas. But in this scenario, the way that the PTO thought of it, this was what they thought was the outcome based upon what they saw in the law. To the compound itself,
Mhm.
so they made this new variant based on what came out of it. Similar in that the people are considered inventors by the PTO guidelines. They determine what the structural modifications should be in order to produce the thing that had the more selective binding. Part of this also is when it comes to more complex technologies like cancer treatment, binding, uh, chemical technologies that involve some sort of biocomponent. The law is that there is law saying that I can't know that something is a more or less selective binder until I test it. And so their reduction to practice happens at the same time as conception, those two being words. So here they're saying, look, M&M are the ones that took this list, took these candidates, and then decided what the modification should be. Where, according to this PTO example, the individuals running the in silico method that generated the initial lead list, they're not inventors with relation to this compound because they weren't involved in what changes should we make, how should we make them, which arose of the compound. Again, some of this is in flux, and some of these assume make some very interesting assumptions, but it's meant to be a guidance. And in terms of this, this is like, let's say, an output of, or something that comes from or derived from the output of AI. And that's a different type of patentable subject matter. So we've been talking a good deal about the AI methods or methods involving AI, but the outputs themselves have independent value and significance, not only for you, but in terms of like IP protection and what can be done. So it can be that you go after the AI, a method of using the AI, as well as the outputs or things that are made from the outputs of the AI. Those are all fair game. And so that might be things that are balanced by the innovation center is to say, well, let's pursue this now and pursue this other thing later, or how to part it out so that it's most valuable for you and for your own research efforts. So there may be things you don't want to talk about with regard to your own AI because you're giving away the quote unquote secret sauce
Yep.
where everyone could do it.
Yep.
But your outputs themselves, very valuable and potentially patentable. So those are a variety of ways forward.
And there are a number of there are a number of examples or instances where certain companies do exactly that. It's like for their patent protection strategies just apply to the AI outputs and what they do with them and how and the use of certain indications for based on those outputs, but they keep the AI system by itself, say a trade secret because because part of the bargaining of the patent protection system is like, yes, you get exclusive rights for a fixed term of 20 years plus or minus, sorry, plus a certain plus whatever patent term adjustment you get from the PTA office, but then you publicly disclose disclose the key details in terms of what makes the system work. You can't keep you can't keep those a secret. So this goes back to the first point all the way at the beginning of the presentation as to determine what components should be kept trade secret, what components should be disclosed with and protected via patents as an instrument.
And so with that, we're at the end. This is like only kind of breaking the surface because it's got pejorative, loaded legal language and a landscape that's complex and ever changing. And what we're really trying to do is say that this is something where innovation center, where an attorney needs to work with you as researchers, as innovators to say,
Yep.
what is the invention? What are the different inventions we see? What's going to be best for you going forward? And so there's just some like touch points here to help. It's not meant to be scary. This is not fear mongering. This is just kind of considerations when you see, hey, we turned this over and they came back and said we have 5 different things. Well, this is where that comes from. Um, just so you know, it's meant to be helpful. But with that, this murky place, an intersection of law and a bleeding edge technology that's evolving by the day, we want to open it up to any questions you might have. I'll end on the last slide that Jalen kindly put on because I understand it's important. So I want to make sure it gets up on the screen for everybody. But any questions you might have, please, we're happy to take them now. If you have questions in the future, you can talk to the Tulane Innovation Center. You can have them route things through us, through any attorney they want to use. This is not meant to be a closed dialogue.
So I actually received a few questions directly
Sure.
that I'd like to ask. Okay, so the first question is, what are best practices for a startup company to maintain and license trade secret protection type IP for AI-based or software technology that involves contributions from multiple parties?
Wow, that's a
Wow.
big one, but
That's good.
I'll be real short. So for you to have a trade secret, you gotta have it like papered internally. Like, what is this thing that you think is the secret? And I say that you think because that's how they're gonna come at you. And then it has to be restricted. If everyone in, let's say, the startup knows what the trade secret is, it might not be deemed a trade secret.
Yeah.
So there has to be some sort of restricted access. And then you probably need to work with someone else to say, like, well, other parties might have some sort of involvement. Well, it depends on the level of involvement. It could be that things are kept secret even with respect to them so that it's still a trade secret, even though there's quote unquote another party. So it's still possible. But kind of the key points are identifying what is the trade secret or secrets, having it so that it's retained as a secret so not everyone has access to it, but there's some way of protecting it. And then if there are other parties, there's a variety of secrecy mechanisms that might still preserve that trade secret. Also, what you can do is have a hierarchy of what your trade secrets are and not give everyone the whole piece of the pie.
Yep.
So that's an extremely short answer for an awesome question. It's very topical, but hopefully is a guidepost.
Yeah, and that's going to really depend on the fact pattern and the complexity. But yes, that's the super condensed version of it.
Awesome. Okay. All right. Another question I got was, how can a startup protect and acquire rights to IP that remains in the realm of know-how or trade secrets from a third party? Should those be licensed separately from any patent rights?
So that
Yeah.
can be a strategy for value. It can be helpful. It might be that you have a license that has parts that work semi-independently because there are restrictions as to what prices and limitations I can put on patent rights because
Mhm.
they're supposed to be limited in time versus trade secret, which could potentially last forever.
Forever.
Well, the sun will
Assuming,
eventually explode, but
or,
maybe
right, or
transport.
assuming there's no breach, but yeah, but yeah.
Right, assuming there's no breach. And copyright. So it could be by way of let's say three different licensing instruments. It could be all in the same. It is possible to license each of those things. There might be different terms. There might be different protections you want to set in place as to what the know-how is and how the know-how itself is protected. But that is possible. The best practice would be keeping it under wraps early and only speaking when you have a non-disclosure agreement and working through the innovation office with that. I say that because oftentimes people will hand you a non-disclosure agreement, just sign here. And the amazing part about that non-disclosure agreement that you receive from them is that it only protects them. And it says something to the effect of you give everything to them. So it's a one-way non-disclosure agreement. Um, so keeping that secrecy early, it's very possible to do. Whether you do it in one instrument or several different parts, it depends upon the deal you're trying to make and the value on a test to each. But it is possible. I would say the best practice depends on the particular technology and know-how involved. So I hate those answers, right? It depends what the situation is. This is one of those unfortunate situations where it will depend somewhat on the situation, but there's a lot of possibilities. The key one being keeping it secret, even in the initial conversation, so that you preserve that value.
The other thing, the other layer that I want, or the other wrench I want to just throw in there is like, once again, when it comes to like trying to move certain components of trade secret into the patent protection, into under the patent protection law, one of the best, one of the key questions that any IP litigator worth over their self will ask is like, well, were aspects of that particular trade secret, secret involved in like a public offering for sale, or some other, or a sale or a public use, right? Which under patent law, anything, if you have, if the invention is either has been sold or disclosed for more than a year, you lose patent protection rights within the U.S. and then that, and if not in most jurisdictions across the globe. So you got to be careful. I mean, you got to be careful. Careful too. There's the commercialization aspect, but you also have to look at the IP risk aspect. If someone wanted to take you down, and if and how it's like how would your protection strategy be viewed from from lens of an actual litigator whose sole job is to break and destroy? So that's another consideration too. And like Jim said, not it's like it depends is not a great is not the most satisfying answer, but it is the most accurate. You've got multiple competing agendas here.
Awesome. And then just one last question for you all. Thank you so much. I know we're coming up on time
That's
here,
fine with
but
us.
yeah, so the last question is, how should a company approach the issue of ownership of know-how or trade secret type IP that involves contributions from multiple sources or employment at multiple places? Does conception or reduction to practice control ownership? What is the standard for joint ownership of the IP?
When it comes to know-how and trade secret, ownership is not necessarily tied to inventorship, not necessarily to who invented it. Um, so that's again a large question, but just to bleed through it, it will depend upon employment agreements that are in place. So those I would say are going to become critical. What are the underlying employment agreements? And you might not know from place to place what was already pre-assigned, pre-given away to another company.
Mhm.
So kind of a first step in that is what are the different employers And that will give you a bead as to what rights, be it know-how, trade secret, otherwise may or may not have been divested already without even them knowing. Because a lot of times those are in an employment agreement that people don't necessarily read through. So that is the key step one to answering any other question regarding that.
Awesome. Okay, and then it looks like we do have actually one more audience question. People are
Sure.
excited. Look at that.
Sure.
Hey, so yeah, I just had one quick question. So like you all were discussing, obviously kind of filing a patent on a AI or ML technique is putting it into the public domain. Do you find a common strategy to protect that is to take like a defensive approach and file on multiple model architectures to prevent infringement by like kind of working around?
So typically within the claims, we have and hey, Kellen's gonna get to hear from you. It's been a bit.
I know, good to see you too.
But yeah, but yeah, because what we try to do, what we try to do within the independent claims, we don't specify the specific machine learning model within the first independent claim. Rather, we specify the ML training model within a dependency. So because in some cases, it's like in some cases you use neural networks. In other cases you'd have in other cases you have random forest or like some other Bayesian distribution. What we typically do is assuming that your novelty it lies within how you trained it. Like, are there specific inputs? Are there specific data for filtering steps that are included? Certain other metrics and metrics and scoring techniques you use to come up with the score. That's that stays in as your broadest independent claim, because the magic there lies in how you trained it, or what refined inputs were used to arrive at your desired output. And then you can cover these alternative machine learning models, whether it's random forest or anything else as a dependency. So that way you can capture any third-party infringers who use the same machine learning model training tricks that you have, and capture them that way, regardless of what specific ML model they used.
Okay, perfect. Thank you. I appreciate it.
Awesome. Well, if there are no more questions, Jim, if you wouldn't mind pulling up that very last slide,
Oh, of course.
we can close us out.
And I apologize because now my PowerPoint is frozen.
Okay, well, I think I can pull it up.
I'll keep trying here.
Yeah, I got it. Okay.
Thanks, Jalen. Sorry about that.
No worries. All right, awesome. Oh. Well, look at that. The machines were definitely listening to us today.
I know, right?
And seemingly we didn't hail them quite firmly or quickly enough. Let's see if I can do this one more time. All right. I guess this just means I need to close more, to close some of the tabs over to my computer. But here we are. All right. So thank you all very much for joining us for this webinar. I hope that you learned more about the right questions to ask, including who or what governs your AI. We learned that inventors must be natural people. And then some of the questions housed within that are how, to what extent did the natural person contribute significantly? Did the natural person develop an essential building block of this technology? I hope you will join us if you're in town for our faculty innovation mixer That's going to be October 15th, 5 to 8 p.m. in our main library, Howie T. The next day, we'll be having a customer discovery webinar featuring our very own Sharon Goldsmith. And then on October 24th, anyone is welcome to join us for our open mic challenge. Open mic night is one of our favorite events, and we're going to be at the shop at the CIC. So once again, thank you for joining us. That's me, as always, saying peace out, and we'll see you next time.
Thank you, everyone.
Thank
Appreciate
you,
it.
everyone. Thank you, gentlemen.
Bye.
Thank you very much.